Hi, this is Gus Fikowski for AP Gov Review, and in Unit 6, Part 3, we're going to be looking at civil liberties with respect to criminal rights. So when we look at a defendant, whether it's in criminal or civil court, we're dealing with Amendments 4, 5, 6, 7, and 8. The only difference is Amendment 7 only pertains to civil lawsuits, so that basically just states that your lawsuit has to be more than $20. The AP Gov exam, I'm not so sure that you need to be concentrated or focused on Amendment 7, but I would definitely know Amendments 4, 5, 6, and 8 with respect to criminal defendants. So when we look at defendants' rights, certainly they are protected by the Bill of Rights, and if they are not followed to a T, this can actually overturn a conviction. So courts are always continuously going to be ruling on what is constitutional and what is not. There are just so many unique circumstances and cases that make their way up to the Supreme Court, and we always see many rulings that come out on both sides of the aisle. Now remember that Unit 6 is all about selective incorporation. When we see that incorporation, remember that means we're looking at a specific aspect of an amendment, and if it's incorporated, that means all 50 states have to abide by that. Most states do have criminal protections already embedded in their own constitutions, but just in case they don't, incorporation makes sure that the Bill of Rights, that particular amendment, is going to be now followed by the states. So if you actually look at a defendant's rights, at every stage of the criminal justice system, one's rights, your rights as a defendant, are always going to be protected. So for example, when the police are gathering evidence, you are already being protected by the Fourth Amendment. They can't just search your house without a warrant. That's where, of course, you are being protected. With respect to suspicion, you are guaranteed a right or the writ of habeas corpus. It will not be suspended, forbidding imprisonment without evidence. You are protected with that under Article 1, Section 9, right there in the Constitution. Once an arrest has been made, you have the right to the assistance of counsel or a lawyer, as per the Sixth Amendment. When you're getting interrogated, you have the right not to self-incriminate yourself, as per the Fifth Amendment. And that when bail is set, it should not be excessively high. So if you just, robbed a candy bar, having a bail at $10 million would be unconstitutional, as per the Eighth Amendment. Once the trial is being held, you are entitled to a speedy and public trial. You are also protected from double jeopardy, meaning being tried twice for the same crime. That is forbidden, again, by the Fifth Amendment. Trial by jury, Article 3, Section 2, also in the Sixth Amendment. And the right to confront witnesses, once again, Sixth Amendment. And then should you be found guilty with the punishment, you're still being protected, with cruel and unusual punishment being forbidden as per the Eighth Amendment. These are very important amendments to know. You need to really get it down because to some extent, part of AP Gov is a glorified vocabulary exam. So really knowing that is going to be very important. Now, with respect to searches and seizures, you have to have probable cause. So when the police have reason to believe that a person should be arrested, then they can do that. Now, with respect to unreasonable searches, evidence that is obtained in a haphazard or random manner is, of course, prohibited by the Fourth Amendment. There's also something called the exclusionary rule. And this is the rule that evidence, no matter how incriminating, cannot be introduced into trial if it was constitutionally obtained or not constitutionally obtained. So, for example, if the police just kick down your door and they find the video of you in your own residence saying, "I committed the murder of Jane Doe," and then they use that evidence against you, that's going to be excluded. And this was came out of a case known as Mapp v. Ohio. Think of, a good way to remember this particular case is think of that you need a map, right? The police need a warrant or a map to obtain that evidence. If they don't have that map or warrant, then of course that evidence is going to be excluded, hence the word that you see here, exclusion. So the exclusionary rule, they don't have a warrant or the evidence is not obtained legally, then it's going to be thrown out. And that is established through Mapp v. Ohio. Typically, you're going to see this Fourth Amendment case come out some way or another on the AP Gov exam. So definitely. So Mapp v. Ohio raises some questions. Does this allow the guilty to go free? Is this a technicality? Or is this actually just protecting citizens' rights? Is the Constitution a series of technicalities? And this brings up issues with the Patriot Act that you could have a warrantless search. Again, with the 9/11 being a major game changer with rights, again, how does this case relate to it? So this is a lot of questions that people have discussed, that this is always working through the courts and certainly is being debated in the media today. With respect to self-incrimination, this just refers to when an individual accused of a crime is compelled to be a witness against him or herself in court. Well, you can certainly incriminate yourself all you want as long as you agree to it and you're informed about it. In the case of Miranda v. Arizona in 1966, the police did not inform Mr. Miranda of his rights. Now, there was no precedent of this in the past, but he said he should have been informed as to what his rights were before confessing. And he's actually let off of his crime of rape. Now, needless to say, he actually is murdered in a bar fight about 10 years later. But nevertheless, this sets a very important precedent which police have to do every time they make an arrest, whether you're in Maine, Texas, Georgia, Washington State, Hawaii, you get the Miranda warning. And of course, this is going to protect you from coerced confessions and entrapment. So again, being a very important Fifth Amendment right that people still concede today. Dealing with the Sixth Amendment and the right to counsel or your right to a lawyer, the state must provide lawyers in most criminal cases. Now, again, the Sixth Amendment just says you have the right to counsel. It doesn't say the state has to provide it, but this comes out of a case known as Gideon v. Wainwright, where you have this relatively poor, uneducated man who says he cannot protect himself. He cannot advocate for himself because he does not have a lawyer. Now, notice that this case, which is going to be in favor of Gideon, states most criminal. So if you're getting sued by your neighbor because you cut down his tree for fun, you're not going to get a public defender. This only applies to criminal cases. Keep that in mind. Now, dealing with trials, certainly you do have plea bargaining where you're going to have the defendant pleading guilty to a lesser crime in exchange for a reduced sentence. And actually 90% of cases end at this stage and never actually go to trial. But for those that do, the Sixth Amendment also is going to guarantee you a speedy and public trial. So a trial cannot be held in secrecy. Again, that it comes right out of the Sixth Amendment. Now, dealing with the Eighth Amendment, that of course forbids cruel and unusual punishment. But again, remember sort of a recurring theme of AP Govs. A lot of these standards that come out of the Supreme Court or the way that an amendment is written can be somewhat ambiguous. What constitutes cruel and unusual? And a very good topic of debate is water torture cruel and unusual? Well, you have a myriad of opinions on that. Is it cruel and unusual to execute a mentally ill person, someone who's a juvenile? So the death penalty is actually not cruel and unusual as per the Supreme Court. It's been called an extreme sanction suitable to the most extreme crime. And that quote came out of Gregg v. Georgia in 1976, which will hold up the constitutionality of course, the death penalty. Now, while the death penalty has been ruled to be constitutional, a number of states have gone on their own to abolish the death penalty. However, it is important to note that it is cruel and unusual, and it has been ruled that it is cruel and unusual to execute a mentally ill person as well as a juvenile under the age of 18. So again, there are restrictions on the death penalty, but it is still legal. It is still applied in various ways by states today. Now, we typically think of the Fourth Amendment as one involving warrants and protecting criminals. However, it is also a privacy amendment in many ways. Now, while privacy is not explicitly stated in the Constitution, it has been implied by the Fourth Amendment as per the U.S. Supreme Court. In 1965 in Griswold v. Connecticut, this will rule that birth control restrictions in Connecticut are indeed unconstitutional based on privacy laws. And this is very similar to the case involving abortion of Roe v. Wade in 1973, that this came down to privacy, that abortion is legal according to the Supreme Court of the United States based on a woman's right to choose, and as a result of that being her own privacy. And again, this has been interpreted from the Fourth Amendment, which is supposed to protect you from government intrusion, and it gives you your right to privacy. So again, that's where the abortion comes down to. With Lawrence v. Texas, this actually strikes down a anti-sodomy law in Texas and rules that the police have no right to arrest somebody for something that they are doing in their own home that is a private sexual encounter. So as a result, these are three important cases that are going to be decided based on privacy interpretations of the Fourth Amendment. And again, I would be very much familiar with them. And again, controversy over abortion. Here you have with the Roe v. Wade and Planned Parenthood v. Casey, again, upholding abortion there. And again, you do have protections of those seeking an abortion based on privacy. And of course, this is an abortion debate where this is very contentious, especially in choosing Supreme Court justices. This is a major issue that divides Democrats and Republicans and liberals versus conservatives. So this, again, just boils down to the Supreme Court, down to privacy. All right, so in summary, civil liberties are expressed in the Bill of Rights. You see them in the First Amendment, from freedom of religion, expression, assembly, and so on. And then you also have your criminal amendments 4, 5, 6, and 8 protecting you against the government. Legislatures and courts are constantly defining what the Bill of Rights protects, and it is incorporating aspects of the Bill of Rights on an ongoing basis for the states to follow. All right, so let's end with a review question. The 1973 Roe v. Wade decision that upheld a woman's right to secure an abortion was based on the right to which of the following? Take a moment to pause your screen. And if you said the first choice, privacy implied in the Bill of Rights as per the Fourth Amendment, you would be correct.